Good afternoon, brothers and sisters. I'm going to start using the old Reformed Episcopal prayer book and just go through it section by section as part of our prayers to open anything up. A couple of my favorites will start on the very first page. The Lord is in his holy temple. Let all the earth keep silence before him. Habakkuk 2:20. I was glad when they said to me, "Come, let us go to the house of the Lord." That opens up worship, sets the tone. We continue our work from hymn 508 in our beloved Episcopal hymnal. Breathe on me, breath of God, so I shall never die, but live with thee the perfect life of thine eternity. Well, we're talking about felony murder rule, which, as I understand it, the big picture is if someone dies while you're committing other felonies, you can be guilty of not only the attending felony, say arson or rape or a burglary. Someone dies, you can be charged with felony murder as well. Let's see how this unfolds. And again, our interest has been the English Reformation, but of course it has applications far and wide. We're quite confident to declare the case settled against the Roman authorities who put Ignatius to death. Malice, aforethought, premeditated, heat, and misuse and abuse of the law. Putting a man to death because he professes to believe in the King of Kings and Lord of Lords and the Redeemer and victim of peace, Jesus. The victim is the sacrificial offering to bring peace between God and his elect. Put to death because of that. So they had felonious, criminal, corrupt influences in their hearts as they did that, and the consequence was their depraved taking of one human life by other humans. In this country, certain felonies have long been regarded as inherently dangerous. Those most frequently assigned to this category are arson, rape, robbery, and burglary. This is in Moreland's Law of Homicides. Dangerous felonies commonly enumerated arson, rape, robbery, and burglary. Common experience points to the presence of a substantial human risk from the mere perpetration of such wrongful acts. The intent to avoid personal harm formed in the mind of the transgressor at the time he embarks upon the felony is no reasonable safeguard that death will not result before he has finished. And it may be added, a study of the cases repeating the formula that homicide committed while perpetrating or attempting a felony is murder will disclose that the other felony actually involved is one which may properly be classified as dangerous, such as robbery, common law rape, burglary, arson, criminal abortion, mayhem, train wrecking. The law covers so many weird cases, doesn't it? Kidnapping, administering narcotics to a minor, injecting heroin into the arm of a purchaser, or child abuse. To test whether the so-called felony murder rule is unlimited form actually represents the law in this country, it is necessary to consider felonies of a non-dangerous character, because such a felony very rarely result in the death of a human being. Few cases actually arise, but it has not escaped attention entirely. The Kentucky court has given a striking illustration in a very famous case. Under our statute, said the court, the removal of a cornerstone is punishable by a short term in the penitentiary, and then therefore it's a felony. If in attempting this offense, death were to result to one conspirator by his fellow accidentally dropping the stone on him, No Christian court would hesitate to apply this hesitation. Isn't that an odd claim by a court? No Christian court. The limitation mentioned in that homicide would be manslaughter rather than murder, notwithstanding. It resulted from the commission of a felony. The leading American decision on this point is one handed down in Michigan. The defendant sold liquor under circumstances amounting to a felony under the law of that day. The purchaser became drunk and died from exposure, but the court refused to hold that the death resulting from this felony was murder. Notwithstanding the fact that the statute has declared it to be a felony, reads the opinion, it is an act not in itself directly and naturally dangerous to life. The California Supreme Court has refused to apply the felony murder rule to the offense of false imprisonment, since when viewed as an abstract offense, false imprisonment is not inherently dangerous to human life. In fact, there's been a widespread tendency to abandon the early notion that death resulting from a felony is murder. In England, under the felony murder rule was abandoned by statute in 1957. Homicide Act of 1956, the Fifth and Second Acts of Elizabeth II. In this country, a few states have retained the rule in its original form. Death resulting from the perpetration or attempted perpetration of any felony is murder. Elsewhere, the rule has been limited, but not in a uniform manner. A few states have essentially the same position as had developed in England, that death resulting from a felony perpetrated or attempted in a dangerous manner is murder. It's got a footnote to 40. Here's the footnote. The felony rule in Maine is limited to cases in which the felony was committed or attempted in a manner that presents serious threat to human life or is likely to cause bodily harm. State v. Wallace, Maine. The killing was felony murder because the felony, theft of a motor vehicle, was committed in a manner that betokened a reckless disregard of life. Okay, under the modern penal code, malice is presumed if the actor is engaged or is an accomplice in the commission of it, or is an attempt to commit or flight after committing or attempting to commit robbery, rape, or deviant sexual intercourse by force or threat of force, arson, burglary, kidnapping, or felonious escape. What seems to be the prevailing view is that the felony murder rule is limited to felonies which are inherently dangerous. As emphasized in one case, a homicide resulting from the commission of an inherently dangerous felony, other than those mentioned in the first-degree murder statute, constitutes at least murder in the second degree. The inherently dangerous felony is well illustrated in Henderson. It's the name of a case. It's a California case, it looks like. Yes. In the 3rd District of California. Under this statute, false imprisonment is a misdemeanor unless effectuated by violence, menace, fraud, or deceit, in which case it is then a felony. Defendant, while falsely imprisoning Rhinesto, is in an extremely dangerous manner, intentionally shot and killed Mrs. Gehuli. The judge instructed the jury on 2 theories of second-degree murder. 1, the killing resulting from an unlawful act involving a high degree of probability of death. And 2, felony murder on the ground that it resulted from felony false imprisonment. The jury found defendant guilty of second-degree murder and conviction followed, but the conviction was reversed because of the error in instructing on felony murder. It was inferred that if false imprisonment was a felony only if committed by violence or menace, then felony false imprisonment would be an inherently dangerous felony. Which I love the way these lawyers and courts work. In the case of Ignatius, man, that's first-degree murder. In the case of Polycarp, first-degree murder. Okay? In the case of the killing of Queen Mary of Scots by Elizabeth I, first-degree murder. You could have kept her in a castle, locked up, without taking her life. She was a political threat. How about the Pope authorizing people to rebel against their king? How about the gunpowder plot in England? Well, we got all kinds of things we can apply this stuff to. This is good. Oh, how about the death of Jesus? Whoa. Whoa, right there. That'll take the breath out of you, wake you up in the morning. We're going to have to give that one some thought. Malice, aforethought. Malice, hatred, ill will, grudge, hatred. He was the Prince of Peace, the Prince of Life. He rose from the grave to bring peace to us as our high priest. Hallelujah. Stop right there. Come on over, Pentecostal. We're praising the Lord again. But since it may also be committed by fraud or deceit, the felony is not inherently dangerous. Defendants insisted that this case should be regarded as involving the felony of false imprisonment by violence or menace was rejected on the ground that there's just one offense, a felony by false imprisonment, committed by violence, menace, fraud, or deceit. Courts have applied the requirement of an inherently dangerous felony in two different manners. In the first, the felony is examined in the abstract, and the dangerousness determined from the nature of the crime. Let me just interject here while I remember this. We've got other criminal law we want to study, such as theft, because we're going to get in the imperial period where property was confiscated because they were Christians. Books were destroyed, which does the crime of felonious arson apply? We'll see. Theft apply. Libel and defamation. Oh, we got a long way to go in this book. But it helps us think and clarify things. And this stuff goes on in the courts all the time. Criminal lawyers, defense lawyers are thinking this stuff. It's been fun for me in previous years to have attended 3 or 4 murder cases here locally. One of them was a particularly brutal one. Enough there. That was a straightforward first-degree homicide, and they got him. And then the other one, I think that was first-degree homicide too. The guy killed his wife and tried to hide it. Michigan, it has been held, has neither statutory felony murder doctrine nor common law felony murder doctrine. Malice is not in that state, imputed to the act of killing from an attempt to commit an underlying felony. Malice may be inferred from the nature of the underlying felony and the circumstance of its commission, but the question of malice in each case remains a question for jury determination. And Colorado has held that under its statute, there is no felony murder rule. Some of the new penal codes place limitations on vicarious liability in felony murder cases. May be provided that it is an affirmative defense that the defendant did not commit the homicide act or in any way solicit, command, induce, procure, counsel, or aid in its commission. More frequently, there are additional provisions such as was not armed with a deadly weapon or any instrument, article, or substance readily capable of causing death or serious injury, and of a sort not ordinarily carried in public by law-abiding persons, or had no reasonable ground to believe that any other participant was armed with such a weapon, instrument, article, or substance. The felony murder rule is often couched in some such form as homicide, committed while perpetrating or attempting, and so forth. This suggests mere coincidences as sufficient for the result, but the actual requirement is causation. This statement, however, must not be overinterpreted. It does not mean that the loss of life must have resulted from a step intentionally taken for the purpose of achieving the felony, but only the felonious felony was a sine qua non. But for the felony, the deceased would not have been killed. Thus, it is not necessary under most statutes to show that the killing was intended or even the act resulting from the death intended. It may have been quite unexpected. If it is charged that homicide was committed during the perpetration of robbery, the only intent required is the intent to commit the robbery. If that intent is shown, the resulting homicide is murder, even if it's quite accidental. If the victim of robbery attempts to disarm his assailant and is killed by an accidental discharge of the weapon during the struggle for possession, the robber is guilty of murder. Furthermore, if arson results in the death of a fireman who's trying to put out a fire, the arsonist is recognized as having caused this death and is guilty of murder under the felony rule. And even the accidental killing of an accomplice during the perpetration of arson is murder for the same reason. In one case, a dwelling was broken into at night for the purpose of killing the dweller. This was a burglary, but the resulting killing was not held to be felony murder. That's weird. While not expressed in these words, the idea was that this was not homicide in the perpetration of a burglary, but burglary in the perpetration of a homicide. Okay, that makes sense. Thus, if D broke, this is a hypothetical, D, capital D, broke into a dwelling with malice aforethought, he is guilty of murder. But if D followed the other into the house in the sudden heat of passion engendered by adequate provocation, he is guilty, not of murder, but of manslaughter. Emphasis upon causation rather than coincidence is important for quite a different reason. Under the prevailing view, if the killing resulted from the perpetration of the design, it falls within the rule even if felony itself had not been completed before the fatal blow struck. It is a homicide resulting from burglary. For example, although the burglar had abandoned his loot, left the building empty-handed, and was running to avoid arrest at the time of his killing. Homicide is within the felony murder rule if it is within the res gestae. Oh, I haven't seen that in a while, of the initial felony. Where is it? 63. Res gestae. It's in the thing of the beginning. It's something of the first seminal idea. They don't give a definition here, but that's my Latin look at it. The res gestae embraces not only the actual facts of the transaction circumstances, but the matters immediately antecedent and having a direct causal connection with it, as well as the actions following from it. The killing during the course of an escape from a robbery or felony is part of the res gestae of the felony, where a robber returned to the premises of the robbery and killed one of the victims in order to avoid detection. The killing is within the scope of the felony murder rule. Wow, a lot on felony murder here. A narrower interpretation. I wonder how that might apply in some of the imperial persecutions of Marcus Aurelius, for example. I'm going to think about that. What were some of the other felonies around that? Confiscation, theft, libel, defamation. A narrower interpretation is found in some of the cases, induced perhaps by a desire to limit the application of an unreasonably broad statute. Thus, when the New York statute included within the category of first-degree murder the killing of a human being by a person engaged in the commission of a felony. These guys are like St. Paul with long sentences. Paul, Romans 1, or Ephesians 1, 3 to 14. We were looking at Romans the other day. And excuse me. Another point must not be overlooked. It would be futile to recognize the sudden heat of passion engendered by great provocation as sufficiently mitigating to reduce a voluntary homicide to manslaughter, if in the next breath it was added that manslaughter is a dangerous felony and hence homicide resulting from such an attempt must be murder. The distinction between murder and manslaughter, felonies both, make it necessary to qualify any rule as to homicide resulting from felony by limiting to felonies other than felonious homicide itself, or else to felonies other than manslaughter. This has usually been taken for granted, but at times has been forced upon the attention of the court. One view is that in order to bring a case within the felony murder rule, it is essential that the slayer was engaged in some other felony, so distinct as not to be an ingredient of the homicide itself. Some courts have rejected this view, although needless to say, it would have to make an exception mentioned as to manslaughter. Legislation in particular jurisdictions may change this rule of the common law, the same as any other. If the statute changes the common law by adding purposefully in the definition of murder, an unintentional killing will not qualify even if it results from a dangerous felony. The statutes of some jurisdictions limit the specific types of felonies to which the felony murder rule is applied. The provision seems to cover every case in which there's a legally recognizable causal connection between the felonious act and the death, except where changed by statute. The felony murder rule in this country should be stated in this form. Here it's got nice big bold print. Here it is. Homicide is murder if the death results from the perpetration or attempted perpetration of an inherently dangerous felony. That's the last several pages. That's the bottom line. Do a burglary, somebody dies, intentional or not intentional, felony murder. You do an arson, not intending to kill anybody, but it kills a fireman, you didn't intend that, murder. Felony rule is somewhat in disfavor at this present time. The courts apply it where the law requires, but they do so grudgingly, and they tend to restrict its application where circumstances permit. It was entirely logical, however, in the day of its inception, when all felonies were punishable with death. We had a Colorado ruling, and then a definition by Moreland in the Law of Homicide. All felonies, with the exception of petty larceny, were punished with death. Whoa. The felony murder rule is, okay, we read that. Since the would-be felon was willing to risk his life, it was relatively unimportant that he became guilty of a capital crime in a different manner than intended. The primary purpose of this rule, it may be mentioned, was to deal with the case in which the homicide was caused an attempted felony that failed. Conviction of felony resulted in total forfeiture, the loss of life, lands, and goods, so that nothing would have been added by establishing guilt of a second felony. An attempt to commit a felony, however, was a misdemeanor at common law. Hence, to hold guilty of a capital crime one who made an unsuccessful attempt to commit burglary during which he caused the loss of human life, however unintentionally or unexpectedly, put the wrongdoer in no worse position in legal theory than if he had succeeded in committing burglary without homicide. At the present time, with the removal of most felonies from the category of capital crime, the reason for the rule has ceased to exist. One who, in the perpetration of an attempted perpetration of arson, rape, robbery, burglary, kidnapping, causes death purposefully or with force, used in wanton and willful disregard of the plain likelihood of causing death or great bodily injury, may well be held guilty of murder in the first degree. The statute might be amended so that homicide committed during such perpetration could be shown to have been so unexpected as to constitute nothing more than manslaughter. The modern penal code would move in this direction by substituting a rebuttable presumption for the unyielding felony murder rule. Well, we will end that here. There's some things to think about again. We'll close with a few sentences from the Reformed Episcopal Prayer Book. Praise waits for thee, O God, in Zion, and unto thee shall the vows be performed. God is a spirit, and they that worship him in spirit shall worship him in spirit and in truth. So even as we consider homicide laws, we see some of the thinking here that arises in the natural realm of the constitution of human nature. Natural law, Romans 2:14 and 15. We're going to read, as is our practice every hour, hymn 509, verse 1. Spirit divine, attend our prayers and make this home thy home. Descend with all thy gracious powers. O come, great Spirit, come. In the name of the Father, Son, and Holy Ghost. Amen. Until next time, God willing, Godspeed.